Good morning, and welcome to the Friday, August 14th, 2026 Planning Commission, Palm Beach County Planning Commission. Precious, will you please call the roll?
Present. John Carr.
Present.
Marissa Laldas.
Present.
Rafael Clemente. Rosie Matos. Jordania Arias. Carl Anthony Klepper. Brian Stenberg.
Present.
Rick Stopik. Ankar Patel.
Here.
Gary Brown.
Here.
Stephen Basor.
Present.
Denise Williams. Cedric Thomas.
Here.
Aaron Halliburton. We have quorum.
Thank you, Precious. Please rise and join me in the Pledge of Allegiance. Thank you. Do we have proof of publication?
Good morning, Chair. Jeff Gagnon, Interim Planning Director. We do have proof of publication.
Thank you, sir. Okay, I see that we have one request for a postponement, and that is for item number 4A1, the Florida Wildlife Rangers text initiation. Do I have a motion to postpone that item?
Motion to postpone.
Is there a second?
Second.
All in favor, please say aye.
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 Thank you. That item is
Chair.
postponed. Yes, sir.
If I may, just for clarification, the request was to postpone to the October 9th Planning Commission hearing, so just wanted to make sure that was part of the motion made by the board.
Okay.
I will amend the motion as Planning Director stated.
Okay, is there a second for that?
Second.
All in favor, say aye.
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 Thank you. Okay, agenda approval. I assume everyone's had the opportunity to review the agenda. Is there a motion to approve the agenda?
Motion to approve agenda.
Is there a second?
Second.
All in favor, say aye.
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 Thank you. Okay, now also we have had the opportunity to view the minutes from the last meeting of July 10th, 2026. Is there a motion to approve the minutes?
So moved.
Is there a second?
Second.
All in favor of approving these minutes, please say aye.
Aye.
Any opposed? Thank you. They are approved. Okay, do we have any comment cards from the public on any non-agenda items? It appears that we do not, so we'll move on to the next. I have no comments at this time. So now we will open the floor for the public hearing. Item number 3A, round 26-B2, the county proposed text amendments. Can we please hear from the applicant at either lectern?
Yes, thank you, Chair. So this is a county-initiated amendment, so I'll pass the microphone over to Brian Davis, Principal Planner with the Planning Division.
Thank you.
Thank you, Mr. Gagnon. Good morning, members of the Planning Commission. Brian Davis. This is, as Mr. Gagnon indicated, the compatibility text amendment. It's in response to recently passed legislation, and so we are reacting to that because of the effective date. So just very quickly to set the rules here, or the stage, if you will. House Bill 399 came out of the 2026 legislative session. It was enacted as, the laws of Florida 26-007, and it amended 3194, the part of the Growth Management Community Planning Act, huge portion that we live in. And 3194 addresses the legal status of the comprehensive plan. Usually it pertains to the consistency of the plan and that determination and how that fits in with the zoning code, zoning regulations, government decisions, development orders. And so this added a section on compatibility for residential uses. And so that's what this amendment largely pertains to. And then for going forward, we're proposing 2 new policies to enact this new legislation. So part of the stage setting is also we need to understand when we say compatibility what it means. This is the sum total, what's on the screen right now, of what compatibility is in the Florida statutes under Chapter 163. There are some other things that I'll just sort of get out of the way as part of housekeeping about, like, if you're adjacent to a military base or, ports, airports. They don't apply. This is what we in our day-to-day look at as far as compatibility of land uses. So we have this very wordy definition in the statutes. Compatibility is a condition which land uses or conditions can coexist in relative proximity to each other in a stable fashion over time, such that no use or condition is unduly negatively impacted, or directly or indirectly, by another use or condition. It's a word or a phrase or a definition that we typically will hash over. It's very long, cumbersome. Most people regard compatibility in a terminology that maybe is more appropriately understood by Justice Potter Stewart in the decision on obscenity, where he says, "I know it when I see it." Most people understand compatibility of it's there or it's not there. That's the fundamental issue with compatibility of, if you know it when you see it, how do you make it an objective standard? So this is one of those attempts to delve into it. The statute also, when we're doing the future land use element, says that the element must include criteria to provide for compatibility of adjacent uses. And I want to tease out a difference between these two requirements, the definition and the actual statutory requirement for the element. The definition requires relative proximity. So there's this notion of it's not an adjacency, which is what the future land use element is required to address. So this is some of the ambiguity inherent in the statute, and the proposed change does not deal with it at all. So I just want to point that out, that we're kind of in this area where even the existing statutory guidance, before we even delve into this, is a little bit loose. So, and I've looked at this for off and on for about 5 years, but then this came along, so here we are. So just to walk through what is required, and I want to say this, 399 addressed a lot of other things. It really only has one line that directly applies to the comprehensive plan, but it has some other add-ons. There are things out there about mobile homes and whatnot, not our issue, but that we now need to consider. But for the purpose of the comp plan, it is simply this: 3194, a new subsection 7 is added under A that says that the local government comprehensive plan and its LDRs must include factors for assessing compatibility of allowable residential uses in residential zoning districts and those categories, the land use categories. So fundamentally, we're just now looking at residential. This is a clarification on residential to residential. It's kind of a little peculiar, if you will. I'm going to put the words on the screen. I'm by no means going to go through this, but just so you can understand that this is the B part. This is the zoning part that requires the land development regulations. Now, zoning decisions, if you're going to recommend denial, you must have written findings and mitigation measures that are there. So part of the amendment that you will see is actually speaking to anchoring those required mitigation measures to address or minimize or resolve an incompatibility. So I'm just putting it there, so if we need to, we can come back and see it. And then finally, the last part of the subsection 7 of 399 addresses the exceptions. So it does not address different or compatibility between different land uses, the non-residential things. So anything that's a mixed use, industrial, commercial, institutional, this does not pertain to. So it really confines and makes it very clear. And then further, it's not for planned unit developments. The way planned unit developments are conceived of, historically, and since they were effectively created, is you address compatibility issues within that zoning district construct. So it does not apply there. It does not apply also to historic districts. So they typically have their own exceptions. So, and then finally, it says that that this subsection does not require you to, if it's inconsistent with something else in your comprehensive plan, this one instance of a residential incompatibility, if it can't be resolved, does not require you to pass it regardless. So I just wanted to kind of set sort of the analysis through so we can get to the proposed language. So this is the proposed plan language for the future land use element. And so what we're proposing is a new policy for those not within planned development districts. So this is effectively parcels that are already subdivided or assemblages of parcels that are effectively coming in and either doing a parcel assemblage or just further developing on an existing, not using a planned development, not using a master plan community as the exception called for. And so we were saying these are the factors that we will evaluate. We will look at the land use designation of the parcel and the adjacent parcels. We will consider the development potential if there's any density bonuses. In other words, are we looking at maybe it's currently built with 1 unit, it could build 5 units. They're proposing density bonuses to make it 10 units, buy a couple more TDRs. Suddenly what's an existing unit now, even though it could go to 5 by land use, they're proposing 12, 13 units. That's the kind of thing that we're saying, those are the factors we're going to look at. If it's appropriate, if we also have zoning, we don't typically look at design that much in planning. We would consider the design attributes, or are there things that maybe we want to address further on the site. The physical integration of the project and its relation to the neighborhood and community. So there could be certain design considerations where, look, it's residential to residential, it's a different unit type, you know, from a single family to maybe a townhouse on a given parcel. That may be an appropriate transition. Suddenly dropping in on 10 acres, you know, 100 townhouses may be a significant change. Not that it's an incorrect change as far as the unit to unit, but the number of units versus single family residential may be inappropriate. So we're saying, rather than try and go very specifically say, oh, this unit to this unit to this unit, kind of doing a transition. So we want to make it clear that physical integration and how it relates, because that can also address impacts as well. And then finally, the extent to which it furthers other goals, objectives, and policies within the plan. An example of this would be, we have language in the housing element about how we're supposed to encourage and support special needs populations. We see a special needs project maybe once every 10, 12 years. They're very, very rare. But a project that maybe was doing a density increase to accommodate a special needs population might be more appropriate. It's, in other words, it's to weigh it a little bit because it does other things. So there may be additional design things that go into that. But those are the factors. And so how this policy would apply going forward with any land use decision, it's residential to residential, we would now evaluate this. Any zoning development order, we would evaluate that. The next policy, though, which is 221Y, is really the direction for the zoning code. And this is, for the purposes of going forward, this is the anchor for future code language that will be needed to implement this. And so, picking up the language from the statute, it shall be amended to include factors for assessing compatibility of residential uses, as well as mitigation and minimization measures for reducing incompatibilities. The first part then goes into the factors. These are a very lengthy list, and it was actually in an earlier draft of the bill, sort of roughly cribbed from it, because it was a pretty good listing of all the things you would consider incompatibility. We're not saying for us, because this is really beyond the level of a comprehensive plan to go into those things, but this is the meat and potatoes of what a zoning decision considers. Things like, what are the style? What are the setbacks? What's the building intensity? Where is it arranged and how is it configured on the lot? How is it accessed? What are the hours of operation? What are the separation? What are the buffering? So we're saying those are the things, that you would look at in further detail at zoning. And then the measures, and we wanted to go a little bit further into the measures and say these are the kinds of measures that could address and reduce a potential incompatibility. So reduction in density or intensity, and that could be within the parcel. Maybe you don't put as much in one place. You don't spread it out evenly. You may sort of skew the density more to one side of a parcel versus another. You could step down building heights. In other words, you could still build, but it appears to be maybe a 1 or a 2-story building at the end. And so the adjacent buildings may be 1 and 2-story buildings, but then maybe within the building it goes up to maybe a 3-story building. But it's a transition effect. What you're adjacent to is much more similar to what's, being proposed. And then in and of itself, the parcel becomes its own transition. So the reduction in intensity, the stepping down of building heights, increased setbacks, that's the typical one everyone thinks of, is you just provide more separation. You might put your retention, additional buffering, maybe the parking field, and then also increased buffering and landscape, which is sort of stock and trade zoning thing. So these are the measures. Zoning is free to come up with others, but this is really the anchor. This may be a policy that does not actually get adopted, but we wanted to at least set the stage for the conversation here. with the BCC at Transmittal and with the zoning division. So to sort of get it out there and say what's in play. So that's the sum total of the amendment. One line of policy, and I've now taken almost 10 minutes to talk about it. The staff recommendation is for approval, so we are consistent. This will be something that will be, the statute requires a January 1, 2027 implementation, so the statute goes into effect then. We're trying to match and get that into effect. So the motion for the Planning Commission would be to recommend approval. With that, I will, in my presentation, happy to answer any questions. Thank you very much.
Great. Thank you. Appreciate that presentation. From the board, do we have any questions? I'll start to my right. Anchor, any questions?
I think Brian did a fantastic job of explaining everything. It was a lot more confusing reading it, but I think your explanation was great. I think the only question I had raised was, is there a list of the exceptions you were talking about? Because like when you said military and airports and stuff, is there a list in the code that gives specifically those exceptions, or is that a staff sort of assumption?
It's in the statute. It's in 3177. It has a lot of things about if you're adjacent to military bases, airports, ports. I've kind of just read those out of because we don't have that situation or we have sufficient separation. I mean, this is almost for like something like, I don't know, Tampa, where they've got like the U.S. Central Command sitting there in the middle of Tampa. That's a whole different thing versus we don't even have really like a reserve, base here or anything like that. So that's really what they're trying to say is you need to address things, and hey, it's more like noise impacts. So we have other provisions that already take care of the airport noise thing. So for us, those issues really don't apply. So I was just trying to say, for compatibility, we have a very
like schools and hospitals and stuff fall in that?
not under necessarily the statute. There could be other things like typical like nuisance or operational concerns. Those are addressed though in the zoning code, and so it's one of the things that the plan typically doesn't go into because it's already reserved for zoning by case law and other statutory
All right,
requirements.
fair enough. Thank you so much. I appreciate it.
Kara, do you have any questions?
Interesting when you talk about, it seems like they're talking about residential uses within residential land use categories, which seem like, because you're in one land use category, that they're already been determined to be somewhat compatible. So you're getting kind of into the minutia of how the effects of one type of residential use against another type of residential use, which seems a little problematic. But my question is about the language, not to be nitpicky, but when you say may include, I just wonder about someone who maybe, because there is a lot of language in there about people who are against, or if you deny them, my concern would be may include but not limited to, kind of, so there is a little more flexibility for the zoning code.
Well, and that was really, it's a good point. The way it was drafted that way was because we don't know exactly what zoning is. Zoning's got to kind of look through it.
Right.
And so that's why I said, I was leading with this policy may well go away and not be there at adoption, depending upon how far zoning gets with the language. We wanted to put it out there, though, really almost for a conversational purpose, and then to anchor. And then this may be a policy that if it is adopted, we may go back to the ULDC shall maintain provisions. That's a fairly typical practice that we have done when we're like, hey, first we're trying to guide it. Now we're saying we just want to anchor it, and it's here. So this is, we don't know that it's this. It could be more, but we're saying, hey, for the purposes of drafting the code, this is our first blush at what we think could or should be in there.
Right. You never know what the future brings as far as.
That's the problem with planning. You don't have a perfect crystal ball. So.
Thank you.
But no, and to your earlier point, I think there was a level of questioning, and because we're on a relatively shorter, I tried to look even as early as this week to see what local governments, because statewide everyone's doing this, and we actually had a call from Palm Beach Gardens asking, hey, could we see your language? We're like, well, you'll see it when we draft it, and then when we released it to the public. So as of last Friday, it was public. Nobody had done anything. There was a lot of right after session, the typical like law firms, lobbyist firms published a bunch of stuff, but there was no insight really ever offered. Some people have suggested maybe it's in response to the Live Local Act from a few years back and all the changes. it may well be that it's one of those things we just kind of looked at. I looked at all the legislative summaries, the staff analysis when it was going through House. I couldn't really find a great, we're doing this because, so we're trying to respond. I don't think this will be a major issue to your point about it is somewhat fine-grained. I think these are relatively easy factors that automatically are considered anyway. We're just calling them out. But we're also giving ourselves sort of a, hey, this is a rule box. It's predictable. If you can jump through these things, then you shouldn't have a plan issue. That's what we're doing.
And then I think a lot of times people don't really consider that there are a lot of uses that are special exception or conditional use that are allowed within these districts too. So this would apply to them.
John, any questions?
Thank you, Brian, for comprehensive presentation. You answered all my questions as well. So no further questions. Thank you.
Verissa?
No questions, thank you.
Stephen?
Stephen, yes.
No questions. Thank you.
I need my eyeglasses on here. Gary?
Thank you for that presentation. Just for clarification purposes, so we're not talking strictly residence to residence.
My reading is that it is residence to residence. We have situations where, say, like a daycare or a church could go in there. We typically, when those uses go in there, we're just saying in that residential future land use designation, that use is allowed. We do not regard that use when it's coming through like a zoning process as being a comparable use. We just look at it straight up as if the land use was institutional. So in that instance, my reading of the statute and what's proposed here is really to address a residential use adjacent to a residential use. We're writing it in the terms of under a future land use provision. But the reason I'm not expanding it is the statute specifically excludes mixed use, which for most people includes a residential use. Those have their own rules and so forth. I think this is truly trying to, and I'm trying to guess what the legislator's intent is, but I think that's really what they're getting to is when you have a residence and another residence, whatever the type of unit it is arranged as, that's what they're specifically addressing.
So they're not talking like if an industry decides to, I'll just exaggerate, wants to drop a nuclear reactor nearby, that wouldn't address that.
No, and I think that's in the exemption in the Part E of the statute where it's, or maybe it's D. Yeah, so compatibility, so it does not apply. So this requirement does not apply. The rest of the stuff that I went through at the beginning about the existing language, that's all we have to address that. I think there's much better law, statute, and regulation at the zoning side than we have here for compatibility. So it's much further defined. I'm just saying for here, what we're reacting to does not actually address that kind of a use being dropped in.
Okay. And last question is, how often is this revised? If you guys, hey, you pass this and then, hey, 6 months later, here's something that's overlooked. Can you amend that at any time, or is it there's a time clock when that's done?
We have an initial 1 year from the statutory enactment to bring the plan into effect. There's some longer term things that we catch every 7 years, the evaluation appraisal report, which you'll start to hear a lot about going forward. We actually saw that at the prior meeting, the initial response. We actually had looked at a larger, let's just rehash all of compatibility, which was way beyond the scope of the statute. We pared it back because we recognize if we're going to go look at the whole plan, why try and do a deep dive on compatibility when we may go back and change how we look at some of that stuff. So we're kind of saying we're reserving it. So to your point, I think we may well be looking at this in the very near future again, not because of this. This is just literally a check the box. We've complied with the new statute.
Okay, answer my question. Thank you.
Thank you. Cedric, any questions?
Yes, I just want to make sure that I had a few questions about this earlier on that I didn't get quite answered. But this is not addressing the use of anything, right?
Well, let me put it forward this way. Whether a parcel is coming in to do any residential use, whether it's single family, a zero lot line townhome, multifamily, this would apply, and then it's adjacent residential use.
So I'm saying like for businesses like the large family home, like where they do businesses inside of those categories, does that affect that?
Are you talking like a home occupation use, like somebody just runs
Yes.
with? That's really addressed in the zoning level detail of how a home occupation use is. Like there's certain things about you can't have like 15 vehicles parked or whatever. I mean,
Right.
so the idea is to keep the scope of impact down to whatever's appropriate for a residential area. So that's really more a zoning level thing. Because that use would already exist, that single family or whatever the use is where that home occupation is going, they're presumed to already be compatible and whatnot. So
would it be like a grandfathered thing in, or
my understanding is anything that's already there is vested.
Okay.
Anything that's new, in theory, would apply, but the home occupation type use, a home-based business,
Right.
should already be, the only way it can be approved is it's already compatible with the existing neighborhood or proposed neighborhood, whether if you got a vacant parcel next door type thing. So it should already be accounted because that's the zoning level control of it. So you don't suddenly expand, take over the whole parcel, turn it into a business that's really supposed to be appropriate on a commercial parcel or something like you've just got a ton of trips, you've got noxious uses, you've got 300 traffic trips a day, that kind of thing. Like no, that's an incompatibility. So what home occupation allows there is going to be compatible. So the existing regulation should take it. This is more for if we're seeing a new use, request of use, change of use, whether that requires some kind of zoning approval of that. I don't see this really affecting existing or new home occupation type uses.
Yeah, if I can, Brian, add to that as well. So, and this is more of a zoning side, as Brian alluded to, but any sort of access to like a large family daycare or uses like that, or home businesses that are provided, by the state as far as accessibility to homeowners to be able to have a home business, this really won't impact that. There's one excerpt of the House Bill 399 that I think is kind of important to read to better understand the overall intent, but it specifically states that references to community character, which is in quotes, or neighborhood feel, which is also in quotes, are not sufficient. So it seemed like the state was trying to ensure that there were specific factors that were being analyzed versus a very general, let's say, staff recommendation or staff report that said, we are recommending denial because of the surrounding community character or the feel of the neighborhood. Like that, what House Bill 399 is saying is that's no longer adequate for residential to residential compatibility.
So it's just taking away I don't want to say it's taking away the ambiguity, but it's basically limiting the ability for just a staff member to use their own discretion as they're trying to clean it up a little bit and provide more.
I think that's
like the factors are more black and white now, where it's the rule book is clearer, I'll say.
Yeah, just to clarify, I think what this is trying to get at is it's trying to make what had been sort of subjective, judgmental criteria, which really weren't clear. It's an attempt to justify them. That's why I actually referenced the Potter Stewart quote, is that you know it when you see it. That's not a standard that you can actually legally enforce. You have to have an objective measure. You need to have criteria. You need to have a standard to say, did it check that box? Yes. Did it check that? It didn't? Oh, then it's not. And
But
so
it says may and not shall, so you still can.
Well, that's to leave the discretion to the zoning regulations to further clarify it. And so if zoning says, you know what, we don't want some of these things, we can come back, take them out. Or I said later we can come back and amend it again to just say that we will maintain these provisions and we can make it a little bit stronger so it's anchored better. But given that you're seeing this at the very beginning of the process, and it's like we've got 2 more public hearings for just the plan, and then zoning's got its own set of hearings on top of that for the code draft to go through. This is still very much a work in progress, but the plan has to lead, so we had to start somewhere. So,
Gotcha. That's all for me. Thank you.
appreciate it. Good questions.
Thank you. Any further questions from the board? No, seeing none, I have no questions. Can I entertain a motion to approve this this matter?
So move.
Is there a second?
Second.
I will open the floor for discussion. Cedric, do you have any comments?
No.
Gary, anything?
None. Thank you.
Stephen?
No comments.
Carissa,
No.
John,
No comment.
Kara.
No comments.
Oh, thanks, Anchor.
Brian.
I have no comments as well. Okay. We'll go ahead and, all in favor, please say aye.
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 Any opposed? The motion passes unanimously. Okay, the next item on our agenda is number 3B, round 27-A, privately proposed amendment, Liberty Airport Center. And can we please hear from the applicant? Good morning.
Good morning. Thank you, Commissioners. Josh Nichols for the record, Wishmont Nichols. So we will go through, I have a pretty quick PowerPoint, and then we can get to some questions if there are any. But this is Liberty Airport Center, and we're actually representing the center and also a incoming tenant, and that's the basic reason why we're here, which is for Rivian. So Rivian electric vehicles. So they have a need for a service station in Palm Beach County. They only have one in Miami, so all the customers who have Rivians are having to go down to Miami. So they've identified West Palm and Palm Beach County in this site due to its proximity to the Turnpike and just central to the county. So that's kind of the overarching reason for this amendment. So project location, as you can see, this is on the north side of Southern Boulevard, just east of Jog Road. This is an existing built industrial center. And as you can see, we're pointing out the building. So that's the specific building that this facility would go into. And it's basically the western 2 or 3 bays. And we have to go through the zoning side, which shows the site plan. But we're going in those last 2 bays of this structure. So where we come into play on the Planning Commission side is, and again, this was before you in April. So we had a unanimous recommendation of approval. It then went to the Board of County Commissioners for initiation. So this is coming back for our kind of final round here. So you have seen this first part, which is in number 11. So what we're basically doing is this is an EDC, so an Economic Development Center. There's only 2 in the entire county. So it's very specific to this area. And so right now, the comp plan discusses industrial future land uses allow vehicular-based commercial uses of an industrial nature, which have impacts similar to industrial uses such as auto repair. So basically, the comp plan was set up to allow for some of those commercial uses that could be complementary in an industrial land use. So what we're doing is we're adding that piece that says the Economic Development Center. So it's basically just adding that in. So this specific site we talked about could benefit from that. As you can see, if anyone goes by, there's empty space in the center, and the EDC is to promote economic development, to promote employment. So a center like this, where you're typically in a warehouse, you're not really getting that many employees. You may only need 5 employees to run a warehouse type facility, but this type of facility would have significantly more, which is good. That's what we want in an economic development center. So we've added that component, and then we've also added that vehicular-based commercial uses of an industrial natures are allowed up to 15%. So I think that was something that staff added, and we're accepting of that. So it's 15% of the gross floor area of the entire center. So it won't be a proliferation, all of a sudden become this giant auto repair facilities all in this development. So it is limited, but it does provide some flexibility for other uses. And then letter B, under item 11 is commercial uses in commerce, and basically where this got roped in when commerce came online, staff added and economic development centers in there, which wasn't previously limiting, and so that when commerce came online, it did create that limitation. So we need to pull that out again to make this 100% feasible. So that's the code amendment piece. The new piece that you had not seen on the previous round was the ordinance 2008-51. So this is the ordinance that approved the original land use change to the EDC, and it had a limitation, as you can see, to just light industrial uses. So again, to have the ability to expand the uses and allow this use in this development, we have to add or equivalent traffic generating uses. So it's a minor change, but it just allows us to go from industrial to allowing those commercial industrial type uses. So go to the next. So again, I won't belabor this, but again, historically, the EDCs actually allowed for an auto repair facility. So if we were to go back in time, probably 15 years ago, you could do auto repair in this exact site. And also any of the MUPDs around the county, so an MUPD with an industrial land use, you could do an auto repair facility as well. So it's weird that this one got kind of pulled out of that ability. So anyways, we're trying to get that reinstated. And we're doing the same thing on the zoning side. So the zoning side pulled out the use from the matrix, so we're putting that back in. So the county's assessment, I'll really let them go into their assessment, but staff is recommending approval, and we're in agreement with the additional 15% gross floor area limitation. And with that, happy to answer any questions. Thank you.
Okay, should we hear from the county first or go directly to questions?
Yes, Chair, staff does have a presentation as well. If the board pleases, Aaron Kramer, our planner with the Planning Division, would like to do a presentation on staff's analysis.
Thank you. Let's hear it.
Good morning, Commissioners. I'm Aaron Kramer with the Planning Division, and the amendment before you today is the Liberty Airport Center privately initiated Future Land Use Atlas and Text Amendment. This is Phase 2 of the Liberty Airport Center amendment process. Here we have a background of the EDC, one of 3 industrial land use designations. The applicant intends to develop vehicular repair and maintenance uses as well as ancillary sales on the proposed site. These would be considered commercial uses. Because the subject site land use designation is EDC, this is unable to occur, and as a result, the applicant has requested to revise the uses allowed within the EDC. The board initiated the text amendment in April 2026, and the request is to modify Policy 224E of the Future Land Use Element to allow for vehicular-based commercial uses in the EDC and remove the restriction of commercial uses as accessory within this designation. The 68.01 acre subject site, outlined in red and white, is located approximately 0.38 miles east from the intersection of Southern Boulevard and North Jog Road, on the north side of Southern Boulevard in the urban suburban tier. Currently, there is a condition of approval as a result of ordinance number 2008-51, limiting site development to light industrial uses. The applicant is proposing a future land use atlas amendment to change this restriction to open the site to other uses that produce the same traffic output. The subject site is in an area that is made up of a mixture of residential development with more commercial and industrial development occurring west along Southern Boulevard and north into the Jog Road corridor. North of the subject site, there are multiple residential uses. Directly north is a single-family residential home, and adjacent to that property is the Communications Workers of America Local 3181 Union Building. Further north of these properties is the Tahari Planned Unit Development, made up of townhomes and part of the Independence Homeowners Association. East of the subject site, past a tree and water buffer, are a mixture of single-family homes and multifamily developments. They lie within the Royal Palm Estates countywide community revitalization team area. South of the subject site, across Southern Boulevard and the West Palm Canal, are residential communities, the closest community being Point of Woods PUD. Directly west of the subject site is AHS Pine Ridge PUD, a multifamily residential development with 288 units. Further west is more residential with commercial and industrial around North Jog Road. Staff assessment. The request is compatible with the surrounding areas considering the current developed uses on the site. It's consistent with comprehensive plan policies, notably FLU policies 122K and 2.1G, as the applicant's request is further developing an employment generating center and is in accordance with the county directions. The request is also consistent with the applicable overlays and planning studies that include the PBIA Approach Path Conversion Area overlay, the Turnpike Aquifer Protection overlay, the Revitalization and Redevelopment Infill overlay, the URA, the HANP, and the Jog Road Corridor study. Due to the site's proximity to residential neighborhoods, it is important future development does not create adverse impacts on the surrounding community. The request meets all level of service standards and per the traffic equivalency statement is expected to lower trip generation than the current maximum allowed from present-day uses. Considering the global effect of the applicant's request on all EDC land use designations throughout the county, Staff is recommending a modification of the applicant's text request to limit the proposed vehicle repair and maintenance uses to a percentage of the site's development in the EDC. This alteration provides the requested operational flexibility while ensuring that the site continues to function predominantly as an employment-generating light industrial development. It is also intended to ensure that EDC designated locations are not used as a means for developers to bypass commercial location criteria. On screen is the modified request with the county proposed change in yellow. This alters the applicant's request to limit vehicular-based commercial uses to 15% of the gross floor area. Staff recommends approval of the Liberty Airport Center FLUA and text amendment with a motion to approve. Thank you. We're available for any questions.
Thank you, Aaron. Okay, from the board, do we have any questions? Anchor.
Do we need to ask for public first, or?
Oh, is there any public comment on this matter? I don't see any public comment.
I don't believe we received
I have no
cards.
cards. No.
No, sir.
All right, perfect.
Anchor. Go ahead and ask your question.
All right. I have a couple of questions. I guess I'm going to start with staff. When you're doing traffic count and you're adding in the use, you're saying ancillary sales use. However, if you look at Exhibit 5, which is your traffic division letter, under proposed uses, I don't see the sales part in there. So how do we know the sales part you put under traffic count studies?
So for this specific proposal, and maybe Josh can respond to the future intended use of the site, but the sales component that was being requested, to my knowledge, was really for final paperwork purposes. So the intent wasn't to utilize this site as a true showroom or to have kind of like an open door to showcase the vehicles. So that sales component was to happen either off-site or I think predominantly online for this specific user. So maybe Josh can respond to that. But there really wasn't an additional traffic impact that was anticipated by that, paperwork signing aspect of it. And again, I'll defer to Josh to confirm that that was the intended use of the site.
Yeah, thank you, Jeff. And so you're correct. So it's an accessory sales. So just like you would do, say, for a warehouse facility with accessory office, you wouldn't do your traffic based on that accessory component of the office. You do it on the warehouse, right? So same thing with this. So the primary use is the vehicle repair and maintenance, and the accessory is the sales. And again, we don't intend, there won't be salesmen here. It's just it's a pickup location basically once you've done all the paperwork online.
Yeah, but I mean, if you're receiving, typically when a trailer comes in and it's wherever it's coming from, you're going to have at least 10 cars coming in for each trailer. And if you have multiple trailers, that's the amount of cars. So that's a trip generation because you're having people come in to receive those cars on top of the delivery, which I don't see being identified in this thing. I mean, you can call it ancillary sales, call it whatever. There is physically cars showing up for delivery purposes. There's physically cars coming in for people to receive the cars. So I think that's trip generation. I don't know how you can get around that. I mean, it might be minuscule, but it is still a trip generation, which I think traffic division should definitely look at and put into that. My other question is just off of my experiences off of what I've seen off of Tesla and what I've seen off of Lucid and all that stuff, I'm assuming you're putting charge stations in also.
There will be a handful of charging stations, correct?
Okay. Are those going to be accessible for any Rivian customer?
They will if they're on site, but otherwise they're utilized by the staff to charge that up.
Fine.
For a
so now you're talking about trip generations based on people coming to charge the vehicles.
Oh no, I should have clarified. It's not for someone to come in and charge their vehicle on their daily commute or something like that. No, it is for if you come for service, you can plug in, or the staff will utilize.
How do you control that?
Because there are several employees on site that will be controlling.
So the employees are going to control who's coming to charge.
Yeah, because you have to be able to log in. You don't just go up and plug in, so they can control that. Absolutely.
And also, If I'm correct, you're building that new building towards in the vacant land. Is that the general idea of what's going on?
No, this is existing building. They're just
You're
taking
using the
over.
existing building, you're just taking over.
That's correct.
Okay. Does the use change, and this is for staff, change the parking requirement?
It typically wouldn't, but that would be looked at through the zoning process.
Okay.
We have someone from zoning here who can answer that.
You want me to respond to that?
Sure.
Jerome Otti with the zoning division. Yes, it would change the use requirement. Right now, it's parked at a warehouse, which is 1 per 2,000, and then we have to discuss how we're gonna, build into this use, being for the parking requirements for this particular.
I was
use.
afraid of that. All right. All right, and then I have I think it's a clarification, but can somebody pull up that ordinance change that's being requested, please?
To clarify, you're looking for the proposed language from one of the PowerPoint presentations?
That is correct.
I believe
Proposed
both.
language on the ordinance change.
Yes, sir.
All right, so the way, if you read it, the way it reads currently is or equivalent traffic generated uses, which means I think that you intended to have a comma somewhere, because the language right now, if you read it, development of the site under the UDC designation shall be limited to a maximum of 1,139,464 square feet of light industrial uses or equivalent traffic generated uses, right? Do you want to clarify how that's reading? Because I think there's a comma needed in there. But, because it seems like it's a general or. And I don't think it's supposed to be a general or.
I think that's the typical language. This is a typical condition that we see on several projects. That's just
Right, but this opens up a can of worms, because if you make it a general or, this is now changing a lot of things.
Well, remember, it's limited to 15% of these commercial industrial type uses of the entire gross floor area. So only 15% could be outside of the industrial, right? So the equivalent traffic uses can't, I guess to your point, can't get out of control.
I'm just saying is what's to say that you can't build a bigger building now if you do it a general or? Because I can do a traffic use, the same traffic use, but the building could be bigger.
Well,
square footage wise.
What's interesting is the actual on-site square footage is about 600,000 square feet, but the traffic actually allows for 1.1 million. So to your point, yes, there could be more built on that site.
Right, and I think that's the clarification I want. I want to make sure I'm understanding that the clarification is we're just saying or for the purposes of the industrial uses, not for the purposes of the square footage. Does anybody else understand what I'm saying, or?
The way we typically do these type of conditions is the initial traffic study comes in and says, okay, this works, this fits. If they're right up against the limit of a roadway where they might trip into a policy 35D issue or something, they typically will just take a limitation to that amount of trips. So that's the maximum impact it can have. What the or equivalent trip generating uses does is it allows you to potentially change it out below that. But the idea is there is an absolute threshold, so you do not create the traffic impact worse than what was initially studied. And so this is a way to manage it. It's just to give some flexibility over
No,
time.
I understand the
Right.
intent of what you're doing. What I'm saying is the language right now is saying it could be or to that whole criteria. which means now you can build a bigger building, you could do a couple other things, as long as the traffic count remains the same. That's what I'm trying to say. I don't think that's the intent, is that?
That is the intent,
The intent is they can build a bigger building if they need to?
if they needed to. But this one's a very strange instance where we've already got, we're talking about future land use with a built site that's not yet been occupied.
So I think to add to that as well, so this was the previously established threshold for this one aspect of the development. So I don't have all of the site plan aspects in front of me for consideration, but I'm assuming that the development team, based on the aerial view of the site, it seems like it was developed to, I'll say, close to its max potential for the reality of the site itself. So even though the traffic generation threshold was for maybe twice the square feet of building that's currently developed on site, that was just one limitation and consideration of the site. So other things like parking was discussed as well. So there'll be other physical constraints of the site that would, limit some of.
Right, so what I'm trying to say is that right now you're saying that equivalent traffic count of 1.1 million square foot, correct? That's the way you're trying to say this.
Right, because and I don't want to speak out of turn, but legally they would have access to that threshold already.
And I agree with that.
yes.
What I'm saying is the way you've written the language is it takes away that 1.1 million number. Because you're saying, or as a separate add-on.
I see.
That's what I'm trying to tell you.
Doesn't take.
Can also obviously be less, right? Like the equivalent, you might have enough traffic to facilitate.
Correct, it can be less.
But you really, when you actually put the uses in there, you might only have the equivalent of 1 million square feet at 700,000 square feet. So it's really just it's a measuring tool to say you're not going to exceed 1 million or what it may equivalent to in the trips. So it's most
No,
likely to be
I
less.
understand the language. It's just English context. Maybe you need to put a comma there, but that's fine. I'll let the other board members go ahead and decide what they want to say on this. So I apologize.
Thank you, Anchor. No worries. Kara, any questions?
Thank you. This is maximum development potential. So this is an actual TPS approved. So this is kind of the pie in the sky, by land use. So this is, I think the language is fine. I understand the concept of converting internal space into uses that generate more traffic initially. So you're saying that this is but TPS would also be something they would have to look at for these uses. Okay, so they would actually look at impacts if they did use some of these equivalents, which they probably wouldn't even get anywhere near. Okay.
Yes.
Thank you.
Thank you, Kara. John, any questions?
The only question I have is, there was a email on July 27th from a resident. Was that, I don't see anywhere there was anything was addressed with that. Did I miss that? Has the applicant?
We did see the email. We hadn't reached out because several of the items were the concern of additional traffic on the side streets in Avocado, and there's no access to any of those roads, nor is the access changing at all. This is just an interior change of use to an existing building. So most of those were concerns that weren't, I guess they were valid in her mind, but the perception, but they weren't true issues.
And from when staff did receive the email, I believe planning staff reached out to the individual as well as providing that information to our engineering division as well for follow-up. But it seemed to be more of a global concern about the roadway network, not only this site specifically, but I think when the notification for this project went out, that kind of opened up the door for the conversation about Southern Boulevard in general.
So it doesn't have direct access, but it's, I guess, in the close proximity. Okay. Thank you for that. The only other question I wanted, and I believe Anchor had it answered, but I wanted to clarify. So even with the trailers, the way it says the proposed daily trips will go down?
Correct. And again, we're still well below the traffic equivalency, because you can see that allows up to the 1.1 million square feet, but we're well below what that equivalency would even be at that point. So, and again, we're not talking trailers of cars like a typical dealership. So we would anticipate you probably have maybe 1 or 2 cars a week that probably come in separate. So it wouldn't be like, you know, Arrigo Dodge getting, you know, 5 trailers worth of cars. That's not how this operates.
Okay. Thank you. No further questions.
Verissa, do you have any questions? Stephen, do you have any questions?
Just to kind of understand the functionality of the business. So there's a Rivian showroom at City Place area, and that would be the main showroom. This is more of just a service and distribution site. It wouldn't be necessarily where people were going on the weekends to look at or test drive vehicles.
That is correct.
Okay. Thank you.
Gary, any questions?
Yeah, so in the beginning, you established that Miami, everyone had to go to Miami. So clearly it's for convenience, but apparently some overflow. So now that's going to be picked up at West Palm. When you say 1 to 2 cars, I guess that's kind of an estimate, but really we don't know. Rivian electric vehicles, and we know electric vehicles are kind of what the future is. So the question, I guess, is a couple questions. How many bays will be in this particular facility to service vehicles?
Actually, I may have it in here too. About 15 bays.
Okay. So how many vehicles are being serviced as an average in a day?
I don't know
week,
that.
in a month?
I don't know that at this point. I don't know.
So when we talk about traffic, that's a variable that would be considered, right?
Yep.
Let's say, and I guess this is for the applicant, that it's wildly popular and, you know, business is a booming, okay? So, I mean, I don't expect to see traffic like at a drive-through, but obviously it's considerable. So when they talk about, when they do a traffic study, I'd like to know how that's monitored. I have a couple questions. I'll just give it to you at once, okay?
Mhm.
How's it monitored? How do you cap or prevent that traffic study? If you say with this amount of people are coming in a car, how do you cap or prevent it from exceeding it? So if it's that successful, and obviously this is done during peak time. So what is it if it exceeds that? How? I mean, we're just looking at a time frame. Is it been, you know, is it monitored after? And how do you define peak time?
Yeah, so again, and I'm not a traffic engineer, and I know that the zoning side of it will handle a lot more of the traffic items, but this is no different than any other traffic. I mean, the county has seen hundreds and if not 1,000 different vehicle repair facilities. So it's based on the amount of square footage as a rate that they've established for a vehicle repair and maintenance facility. So in that ITE number that they come up with to establish per square foot, it includes how many employees are involved in the transaction, how many customers they expect, and based on that square footage is how many repair bays that would be involved. So all of those components come together for that ITE, which is their traffic standard. And so that's based on the square footage of the use, and that pops out the number of how much traffic is.
All right, so don't get me wrong. I like EV vehicles, okay? But it's kind of like, do we have anyone here from traffic and staff that could answer the question? No. All right, because at this point, it's coulda, woulda, shoulda. I would just like to know those questions, which that's not in your wheelhouse. I mean, you presented some good information, but those answers, I guess those questions have to be answered by somebody in traffic, so.
And that will be done on the zoning side for the specific use, because we haven't submitted the actual use side through zoning.
All right.
So that's where
Let the zoning people answer it, I guess, then. Thank you.
Thank you, Cedric. Any questions?
Yes. You said in your presentation that this was already allowed, but it wasn't anymore, and now you're asking for it to be reinstated. And maybe this is a staff question. Why was this particular use taken out for that location?
So if I'm correct in remembering the part of the conversation, I think it was a reference that Josh made to what was referred to as a use regulation project, which was a zoning side project as far as uses within the ULDC. And I don't have that information directly in front of me. Maybe another staff member remembers, but there was an attempt at that point in time to help clarify uses. However, with any project, what we see over time are there unintended consequences. So I think Josh was mentioning historically that use would have been an allowable use, and then based on the use regulation project, the definitions were changed, the specific uses were changed. So that's what created a new obstacle for that use at this location.
And this just may be for me. Haven't always been that great at math, but the 15% usage for the square footage. Can you just help? Just I'm telling you, it's just probably me. Everybody else may understand this well, but can you help me understand why is that significant, and how does 15% of whatever? Because you're only going to have the last bay, right?
Correct.
So how does that coincide with what you're actually trying to accomplish?
So, and that was a staff recommendation, but I'll give you my side of it. So there's about 600,000 square feet of total square footage that's approved for the site. So 15% is about 90,000 square feet. So that would allow other, like I said, it's kind of creating that flexibility to bring in other uses to hopefully fill these spaces. So it's not only us, but it would allow for other uses similar, perhaps in the future, to come in and occupy some other facilities. So we have up to 90,000 square feet development-wide to be able to include some other uses.
You individually, or you saying it's 15% for the entire project?
For the entire project.
Yeah, so this was a staff-driven condition, and this was based on our concern of a proliferation of this use throughout the entire site, not only this site, but any EDC site. So what this does, it allows Josh and his client to proceed, and it also provides additional flexibility if that specific end user wanted to expand in the future. There's flexibility there, or if there's a different end user that wanted to occupy the same larger development, that would be possible as well. But with currently Senate Bill 180 exists, which would prohibit us from scaling back any allowable use once it is put out there. So we thought it would be prudent to have this 15% threshold to start with, and then in the future, if this was something that was seen as a positive use within EDC, we can always go back and increase that to, let's say, 20%, 25%, whatever could be appropriate in the future. But without having a 15% threshold at this point in time, it would allow unfettered access to utilize this type of use within the EDC future land use.
But doesn't that put a cap on the businesses that will be there and their ability for growth?
Well, currently this specific type use is not allowed within EDC, so that was part of the origin of the request.
Okay, so you're horse trading, basically.
I'm sorry?
You're horse trading?
Well, we're ensuring that the business is able to move forward. So we're anticipating that because the space isn't utilized by another company or individual, that the market is driving this. So the 15% allocation would allow this business or a similar business to expand within that EDC area, while also not potentially outcompeting another business that would currently be allowed in the area.
So if Tesla or Lucid or any of these other, I don't have an EV, I'd like to get one day, but so any of these other, is that trying to just stop the competition from?
Right, and this language, it's not specifically for electric vehicles only. So this is opening up the uses to any vehicle type of service and repair. So this is not only electric vehicles. So again, that was also part of the reason why it could be any brand, any end user. So we wanted to make sure that there was a threshold as far as how that rollout proceeded. And again, we can always go back and open the door further if appropriate, but once the door is open, we can't close it at this point.
So you can increase it without any issue if need be. So if this particular applicant says, hey, business was really good since we moved it here, we now need, more space to be able to do our business, you saying that you could just increase it without them having a delay or stopping business progress?
Yeah, so we believe that 15% number already provides that opportunity for future growth, so they wouldn't have to come back through a process. But again, it also provides a safeguard so that if they are really successful, they're not going to take over the entire development site.
I see what you're saying. Let me ask just the applicant one thing. Do you think that you would ever need more than 15%? Like, say, in the next 5 years, that you need more than 15%?
So I was just asking one of my colleagues. So we're coming in at about 42,000 square feet. So we would take up almost half of the availability. I don't anticipate in 5 years that they would. I don't know. I can't guarantee that, but I don't think that they would outgrow that within the 5-year span. No.
So you saying of Tesla, which I don't have, that if they want to come in for that other 40+ thousand square feet, they could without an issue, but that would be it. It would just be you, and so the person that wanted to work on gasoline powered vehicles wouldn't have any space to do it at all.
Correct. If that square footage was utilized by other businesses, so it would be for EDC at this location. So there are other locations throughout the county that this type of use is currently allowed at, but just not within EDC future land use.
Understood. That's all for me, Mr. Chair. Thank you.
Thank you. I have no questions. Can we entertain a motion to approve this item?
I'll make a recommendation to approve the comprehensive plan amendment as approved by staff.
That is your motion. Is there a second?
Second.
Okay. Shall we do a roll call vote? Oh, I'm sorry. Yeah, we don't vote yet. We have to. Is there any further discussion on this matter? Thank you, Anchor. I appreciate that. I'll start. Actually, I'll start with Cedric. Further discussion? Gary, any discussion? Okay, Stephen.
No.
Marissa. John.
I want to wait to hear what Gary has to say first.
Kara.
No further questions.
Anchor.
I mean, I'm an English stickler, so I'm stuck on the comma. I think there should be a comma after the word square feet in there, because it's an or between light industrial use and equivalent traffic. It's not an or for the actual square footage totality, where you could build a. So what I was trying to say is, let's say, for example, the count that you're allowed right now for traffic is, let's say, 5,000 trips. And I'm just throwing that number out there. The 5,000 trips could retroactively go back and go for a higher square footage. So you could theoretically tear it down and build a $2 million square foot facility the way the or is written right now. By putting the comma after square feet, you're saying it's either light industrial use or equivalent traffic count. So you're saying that the square footage is fixed, but you're saying the use can be either or, if that makes any sense. That was just me being a stickler about English language. But if staff is okay with it, staff's okay with it. I'm fine with it. I mean, that's just me being a little annoying here. But besides that, my only other comment that I have, and this is more for when zoning gets at it, is with EV, there is some hazardous stuff that can come into play with lithium-ion batteries and stuff like that. So I think disposal and or how that stuff is gonna, if there's any drainage or thing that's involved, be important, because there is a creek right across the street. And so their retention pond is seeping into that. So any drainage going off this property is going to go into that retention pond, which is going to end up in that sort of creek that's across the street. So I think it's imperative for zoning to figure out whatever they do in their conditions for doing this specific use, and just be proactive about it. But other than that, I'm in support of this project. I think it's needed. I think it's fine as long as I don't think noise levels on an EV site are as high. So I think it's appropriate for the residential use for the area, and it's interior to the most part. I would hope that it does become a situation where you're getting 20 trailers, but you're probably not going to be there. So I don't see the trip counts there. But I do think that the traffic division letter probably needs to be corrected. So on record, you do have that use as a use in there, because you don't want somebody to come later on and challenge the fact that you're trying to do a use, but the traffic count didn't have that in there. So that's the only comments that I have for that. But otherwise, I think it's a good idea and it works well. Thank you, Chair.
Thank you. I have nothing to discuss. I think you wanted to defer a little bit. What do you got to say, Gary?
All right. Quickly, I just want to know one thing, and you brought up a piece. First of all, the questions I asked about trips, I guess we'll have to defer that to zoning to answer those questions. I think they have to be answered just so we know what they are. I don't want to be a stick in the mud, but I guess I am, so here I am. The question is, and you brought up a good point about there's lithium ion and there's also phosphate. And as we know, there's a fire. Basically what the fire code right now is let it burn. And when you have a burn with those kind of batteries, it does give off toxic plume. So I just want to know how that's going to be handled. So I guess that's something you'd have to find out from your fire marshal. Also, how many batteries are going to be stored at that location? Because if it's a service center, that's a battery issue. How's it contained? How does it protect the public? So I guess these are questions that we'll have to go on to zoning to find out. But that's it. That's all I have. Thank you.
Nothing? We're good? Okay.
If I may, Chair.
Yes, sir.
I have a feeling like you're leading into a potential calling of the motion, but I think we had a member step away, and I think we need him for a quorum.
Yeah, we'll wait for him to return.
Thank you, sir.
In the meantime, we can talk about punctuation and commas, semicolons, colons,
As
M
the staff
dashes,
member
N
mentioned to me
dashes.
that it's an Oxford comma.
Oh, Oxford comma. Okay, but I don't. Is it an Oxford comma? Because is it listing? Is it a list of things? Awkward comma could be. That may be the case.
Call it a semicolon for all I care.
I just want to figure out a way to buy the land and put $2 million on there just for him.
Yeah, and how can you build a $2 million warehouse? That'd be good too. So I'd like to note that my mechanic who services my gasoline-powered car drives an EV because he does. He believes in the idea of not being having shoemakers' children. So let's call this to a vote. We have a motion on the floor and a second to approve. Let's go ahead and do a roll call vote.
Kara Erin Ferris.
Yes.
John Carr.
Yes.
Marissa Laudas.
Yes.
Gary Brown.
Yes.
Ankar Patel.
Yes.
Stephen Basor.
Yes.
Cedric Thomas.
Yes.
Brian Stenberg.
Yes.
Motion passes.
Okay, so now it's time for updates and comments from our commission members, and I'll start with Anchor.
There's a reason why I'm at the end, right?
Yep.
No, I think, Brian, you did a fantastic job explaining. I really appreciate the thoroughness of what you try to do, especially on a vague topic that the state puts out there. So I do appreciate the effort and what you've tried to do. And I think overall staff has been very good with everything that they provide. So I do kudos to them on everything that they do. No, that's about it. I mean, it's hopefully it gets a little cooler at some point, but that's it.
Kara? John? Marissa?
Nothing further.
You're making my job easy. Stephen?
Nothing further.
Gary?
I won't break the streak. Nothing further.
Cedric?
None here.
Okay, I just want to say thank you to staff, and I agree, Brian. You did a wonderful job on explaining it. Some of this stuff can be a little bit dry, and I appreciate the fact that there are people who understand it and who study it, who understand how to explain it to other people. That's a very good gift, so I appreciate that. Thank you. Okay, so Executive Director, do we have any comments or updates?
No comments. There's going to be our comprehensive plan meeting. It's on the 26th of this month, so there will be a lot of great items. I'll follow up on the Ag Reserve items, some other things. I don't know if Jeff was going to mention any of those, but we thank you for your service today and appreciate all of you. Thank you. And my staff, of course.
Thank you. Assistant County Attorney. Nothing. Jeff.
Yeah, Ms. Carroll, Executive Director, read my mind. So yes, planning BCC hearing is August 26th. So the countywide transportation master plan will be discussed, CTMP, as well as the Ag Reserve follow-up, in addition to additional items that I won't name all of them, but we'll have a busy agenda. And as always, I thank all the board members for your service and volunteering your time for Planning Commission, and definitely appreciate all of your input and comments. Thank you.
Thank you. If we have no further business, then we are adjourned at 10:28 a.m. Thank you.